All rise. Veuillez vous lever.
The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Thank you very much. Welcome, everyone. Court officer, please, the case.
Good morning. Yes, Mr. President. Situation in the Republic of Kenya in the case of the prosecutor versus William Samoei Ruto and Joshua Arap Sang. Case reference ICC 0109-0111, and for the record, we are in open session.
Thank you very much. Appearances?
Good morning, Your Honours. Happy New Year. For the prosecution, Anton Steinberg, and with me from front to back, Meda Begaliev, Alice Zago, Regina Weiss, Edward Jeremy, Grace Go, and our intern, Danya Centeno. Thank you.
Thank you very much.
Mr. President, Your Honours, good morning. Mr. Ruto, who is present in court, is represented by myself, Kareem Khan, along with Mr. David Hooper of Queen's Counsel, Mr. Esafal, Dato Shamla Alagendra, Ms. Lee Laurie, Mr. Anand Shah, Ms. Grace Sullivan, and Ms. Clara Gerard Rodriguez. I'm grateful.
Thank you.
Good morning, Your Honours. For Mr. Sang is present. I appear for him together with Dr. Caroline Buisman, Philemon Koech, Joel Bosek, and Logan Hambrick. Present also Cynthia Bondi and Marianne Ukwichise. My name is Katwa Keegan. Have a happy year, Your Honours.
Thank you.
Thank you, Mr. President, Your Honours, and Happy New Year. I am Wilfred Nderitu, representing the victims participating in the proceedings. I'm assisted by Mr. Ochlon Narantsetseg and Mr. James Mawira. I thank you.
Thank you very much, and welcome everyone to the proceedings and to the new courtroom. It will take getting used to. It's much bigger than what we're used to. But in addition to that, this is a brand new courtroom, the very first time we're holding proceedings in this courtroom, in the central courtroom. We have done a mock trial before the last month, I believe, to test the systems. But this is the first time we're doing a real case, and there may be the occasional glitch now and again as we work the system through. So if that occurs, I would crave indulgence of everyone while we work out the system. And thank you. Now, we are convened today to hear oral arguments of the parties on the motions filed by the defense to the effect that the case should not proceed any further and should be dismissed, having heard all the evidence that the prosecution has called in the case. The point of the defense motions is that the evidence called by the prosecution does not disclose sufficient evidence that even at the prima facie level warrants calling upon the defense to adduce their own evidence. That is to say, that the case should now be dismissed with judgment of acquittal because there is no case for the defense to answer. The shorthand colloquial reference to that kind of move in a case is called motion or submission of no case to answer. As to be expected, the prosecution in this case disagrees with the defense motions. The OTP insists that they have called sufficient evidence that warrants calling upon the defense to present their own evidence in the case if they have any to present or if they want to present such a case. In a moment, I shall call upon the prosecution to kick off the debate, but before I do so, there is a brief inquiry that I wish to direct to the defense.